Short.
Hi everyone, my name is Karanbir Singh and I am representing a case under Human Rights Tribunal of Ontario in which the applicant is Sloan Stacy and the respondent is Just Energy Corporation. And the issue of the case is there any evidence that Stacy Sloan's pregnancy related termination from Just Energy constituted sex-based discrimination? And the case facts are Stacy Sloan was employed by Just Energy as a recruiter in their Ottawa office, and she was selected as a recruiter where she was in charge of finding applicants for some positions or roles as independent contractors. And Sloan began working on March 28, 2011 with Just Energy Corporation, and on April 14, 2011, during her first trimester, she told Lucy Trotter, who was her supervisor, that she was pregnant. And after this, on April 18, 2011, Sloan employed was terminated by her supervisor. Just Energy asserted that worries about Sloan's performance and fit within the company contributed to the decision to fire her before any acknowledge of her pregnancy. And the arguments made between Sloan and the corporation were: Sloan contended that the decision to fire her was influenced by her pregnancy but not by her performance, because it was purportedly made after she disclosed her pregnancy to her supervisor. And she argued that there were indications of prejudice because of the timing of the termination shortly after she revealed her pregnancy to her supervisor. Just Energy contended that the Sloan's employment was terminated based on documented performance difficulties and organizational fit without any knowledge of her pregnancy. And it is said that Lucy Trotter, who was her supervisor, that it took the choice to fire her, that the Sloan's pregnancy had no bearing on the decision. And the findings of the tribunal were: the tribunal concluded that Sloan's supervisor had decided to fire her because before her ever being aware of her pregnancy, and the tribunal found that the employer had reasonable doubts about Sloan's performance and fit in the company, even if Sloan thought her work was getting better. But based on the information submitted, the tribunal determined that the Sloan's employment termination was not discriminatory. It was based on her performance, not on her pregnancy. And the remedy ordered: since the application was denied by the tribunal, Sloan did not receive any order of the remedy. And the implications of the case is: it is the responsibility of employees to guarantee that decisions about termination are found on valid grounds that are unrelated to protected features like pregnancy. In order to effectively defend against discrimination allegations, performance difficulties must be communicated and properly documented by both the parties and the tribunal court. In an employee feels they have been subjected to discrimination at work because of a protected trait like pregnancy, they should be informed of their legal rights under human rights laws and should get legal counsel. Employees should also think carefully about when to reveal personal information in regard to hiring decisions. Thank you.